welcome all of you today on this wonderful sunny Wednesday. Of course, the province recently announced legislation that offers up to 3 sick days for employees who have to miss work because of COVID-19. And so we thought it prudent to bring all of you together to help navigate what that means for you, your business as employers, and of course for your employees as well. And so we of course also have Christine Ashton, our expert in employment law and tax, with us here today. With that, I won't take too much more time. I will hand it right over to Christine for the presentation. So welcome, Christine. Thanks for being here.
Thank you so much, Nicole. So as Nicole mentioned, we're going to be talking about the COVID-19 sick pay. What I'm going to be doing is I'm going to be going through a presentation, and that's going to what I'm planning on doing is sort of taking about 30 minutes time to go through the presentation, explain the new sick pay entitlements, and then I'm going to leave 30 minutes of time to answer any questions that you have. And it's fine if your questions aren't exclusively limited to sick pay. If you have other questions about COVID-19 and how it's impacting on employment law or your workplace, please feel free to ask those questions as well. But I won't be dealing with questions during the presentation. I will be dealing with them afterwards. So to the extent that you want to put in your question in the chat box, I just ask that you make it clear as to what you're referring to in your question, because if you say, I'm confused about this slide, when I read it in 30 minutes from now, I'll have no idea what slide you're referring to. All right. So let's get this started. Okay. So, all right. So as I'm sure you all know, COVID-19 has obviously changed in many ways employment law in Ontario and Canada as a whole. And so what we're going to be going through today is talking about the new COVID-19 sick pay. So on April 29th, the Ontario government passed a bill which amended the Employment Standards Act. And the Employment Standards Act is the main piece of employment legislation in Ontario. And this legislation applies to all provincially regulated employment relationships in Ontario. So essentially, if you're a bank, if you operate a trucking company that goes across borders, if you're a radio company, this webinar is not going to help you because the Employment Standards Act does not apply to your employment relationships. But for 90% approximately of employers in Ontario, the Employment Standards Act is what governs and determines a lot of your obligations as an employer. The COVID-19 sick pay obligations are provided for in subsection 50.1 of the Employment Standards Act. And these new COVID-19 sick pay days are referred to as infectious disease emergency leave pay, or Idel pay. There's a few different sources of where you can find out information further to these new Idel pay obligations. So the first is actually looking at the bill itself, and I provided the link here. The second would be to reviewing the actual amended Employment Standards Act. And I know some of you were probably watching. They've now actually posted the amendments to the Act, so you can view those there. And then finally, the Ministry of Labour has a manual. It used to be a physical thing, now it's purely electronic. They have a manual called the Policy and Interpretation Manual, and that provides the ministry's explanation as to how different provisions in the Act work. It's quite a helpful document, especially because oftentimes the Ministry of Labour goes through examples in explaining how certain provisions work. And the Ministry of Labour has updated the manual to deal with Idel pay as well. And I've provided the link for that here. Okay, so how does it work underneath these new Idel pay obligations? So although the legislative amendments came into effect on April 29th, it's actually a retroactive piece of amendment in that it applies as of April 19th, 2021. So, and it provides that employees will be entitled to that Idel pay if they're on a qualifying designated infectious disease leave or a qualifying DIDL. Now, In most company policies, I'm calling it a did leave, but since myself and the legislatures obviously have the sense of humor of a teenage boy, I'm going to be calling it a diddle throughout this presentation. So what is a qualifying diddle? So a qualifying diddle is one of the following 5 things. So 1, the employee is getting a vaccine or is recovering from a vaccine. 2, the employee is essentially getting treatment or is underneath medical investigation or supervision in regards to COVID-19. 2, the employee is required to quarantine or self-isolate in regards to COVID-19. Number 4, the employee is placed on a leave by you, the employer, because of COVID-19. And then finally, in regards to the first 3, the employee is providing care to a defined person. So that's from like their child, their spouse, their parent, in regards to 1, 2, or 3. So as some examples, if, for example, you have an employee who went and got vaccinated but is not feeling well and needs to take time off, they would be on a qualifying diddle. If you have an employee who has a child that needs to be tested because of a potential close contact, then that employee would be on a qualifying diddle. If you have an employee who has recently told you that they went to an amazing house party on the weekend at an Airbnb, you would then be placing them on a diddle. So those are all examples of what would be a qualifying diddle. Now, it's important to note, though, that there are other reasons that an employee could be on a diddle. And for individuals who are on a diddle, some of them qualify for Idel pay and some of them don't. So on that last slide, these were all the reasons why someone would be entitled to Idel pay. But a person could be still entitled to a leave in regards to COVID-19 underneath the Employment Standards Act without being entitled to Idel pay. And so one of those examples, and the most commonly acknowledged example, is someone who has to take a leave of absence in order to care for their child due to a school closure or a daycare closure. So for those individuals, even though they're on a proper diddle, a proper COVID-19 leave, they're still not qualifying for that Idel pay. So it's very important that you're mindful of that, so that when you are determining, I'm putting you on a leave of absence, that you're acknowledging, is this going to be a leave of absence that's a qualifying leave or non-qualifying leave for Idel pay? If someone asks to be placed on a diddle, so a COVID-19 leave, as an employer, you are allowed to ask for reasonable documentation. But what you cannot ask for is for a doctor's note. And I just want to be clear on this, though. You can't require that an employee provides you with a doctor's note, but if they give you the doctor's note, it's not as though you have to be like, no, I can't see it, I can't see it. You can still take the doctor's note. You just can't require it. So I do recommend that when you're communicating with an employee, to avoid any confusion, you don't say to them, here's the things that you could provide to me, because sometimes that can cause an employee to think they have to give you a doctor's note. But if you think about going back to the reasons for what qualifies for Idel pay, a lot of these things don't actually require a doctor's note. So for example, if someone says they're recovering from a vaccine, well, if you're following social media, you would know, or if you've gotten vaccinated yourself, you would know that everyone gets a little printout that says they've been vaccinated. So that is something that would be reasonable documentation. If someone has been told by public health that they have to self-isolate, they normally would receive a written communication from public health in that regard. If someone has tested positive, they would have the test results from that. So there is documentation for essentially all qualifying COVID-19 leaves or diddles that go well beyond you having to ask for a doctor's note. Now, I will also say, though, that you do have other obligations as an employer that go beyond the Employment Standards Act. And one of those obligations is underneath the Human Rights Code to accommodate an employee. So if, for example, you have an employee that's asking for time off because of having to, because of an autoimmune disease that they have and concerned with an infection in the workplace, it could be that you still are entitled to and able to ask for a medical questionnaire to be completed in order to determine if this employee could be accommodated in the workplace, for example, by providing them with additional PPE in regards to COVID-19. So even though you are not able to ask for medical documentation underneath the Employment Standards Act in regards to a COVID-19 leave or a Idel, you are still able to ask for that if you're asking for it further to other legal obligations, such as underneath the Human Rights Code. So if someone is on a qualifying Idel, then that person is entitled to Idel pay. And that Idel pay is a maximum of $200 per day for up to 3 days. If an employee earns less than $200 per day, then you use their regular wages in order to calculate the Idel pay. You do not, however, include other entitlements such as overtime pay, premium shift pay, holiday pay, and so forth. So if it just so happens that they get vaccinated the day before Canada Day and they need to take Canada Day off and they were going to be working on it, you would then calculate their Idel pay based on what they would have normally earned, not based on including what they would have received because they would have been working on Canada Day. Now, the provisions provide that an employee is entitled to take a total of 3 paid days of leave. And the Ministry of Labor has shared that their position is that this means that the employee only gets 3 days forever, as opposed to 3 days per leave. So as a result, if an employee takes multiple Idels or multiple COVID-19 leaves, then that employee is still only entitled to 3 days. There is some questions about the interpretation of this language, whether it means forever, whether or not it means per employer. So if someone works somewhere and then gets another, and then leaves and then gets a new job, are they again entitled to another 3 days? So there are some questions about that. But the Ministry of Labor has provided their current position is that it's a maximum of 3 days, no matter how many COVID-19 related leaves they take. The other thing that's important to note is that currently underneath the amendments, this entitlement to Idel pay is supposed to end on September 25th. Now, the government, of course, can push it out, but I think we can all anticipate that this end date is based on when the government is speculating that will reach herd immunity or have at least 70% of Ontarians having had the double shot, and therefore no longer feeling that this Idel pay is something that needs to be provided for. Now, as I mentioned before, the entitlement to the Idel pay is retroactive, so it goes back to April 19th. So what about those employees who were on already a leave at the time that this legislative amendment occurred? Well, the government has provided that those employees are entitled to Idel pay, but they actually have to submit a written request to you, the employer, by May 13th in order to receive that Idel pay. Now, how many employees are actually going to know to do that? I don't know. And of course, there's nothing wrong with you as an employer letting them know in any case that they're entitled to this Idel pay, especially if they're still off on a qualified leave in any case. I'll also note that some regions, such as the City of Toronto, have stated that they are requiring that employers communicate sick pay entitlements to their employees. This isn't something that is provided for within the legislative amendment. So there's no requirement for everyone across the province to do so, but different public health have required that employers communicate sick pay entitlements, which would now include this Idel pay entitlement. If you do pay out Idel pay, so let's say you have an employee who was off on a qualifying diddle and they were entitled to and received Idel pay, then your business is able to apply to the Wsib, the Workplace Safety Insurance Board, for reimbursement. There is no clear limitation for employers who are not currently registered with the Wsib. And in fact, many employers throughout Ontario are not registered with the Wsib because they're not required to do so, such as accounting offices, law firms, and so forth. You will have to submit that application for the Idel pay within 120 days of the payment or by January 25th, 2022. And that date, of course, is based on the September end date. And it's important to note, of course, if you decide to top them up, if you decide to pay an employee more than the maximum Idel pay, being more than $200 per day, the Wsib is not going to be reimbursing you for that additional amount. When I last checked, it wasn't yet addressed on the Wsib's website, but I've provided here the link for the webpage where the Wsib is sort of sharing how to address COVID-19 in the workplace and claims regarding employees who have COVID-19. And I would expect that that webpage will also shortly have how to submit an application in regards to Idel pay. But since we have 120 days to do so, it's not as though there needs to be sort of a mad rush to go and get your Idel pay applications in right away. Now, some of you, of course, will have current policies in place in regards to sick pay. So what does that mean? So first of all, it means that those employees will be entitled to whatever is greater, the new ESA entitlement, so the new Idel pay entitlement, and their current contractual entitlements. When you're making payments further to the current contractual entitlements, you as an employer will not be eligible for reimbursement from the Wsib. So, you know, no good deed goes unpunished here. If you were an employer that had already stepped up to the plate and was providing sick pay, you are now unable to be reimbursed from the Wsib in regards to it. So how does this work? So I give an example here. You have someone who's off on a COVID-19 related leave, and then the company provides for 2 paid sick days further to its policy. What does that mean? The employee is then entitled to 1 more day as Idel pay because the legislative entitlement was 3 days and you as an employer were only going to be giving 2 days. So think of it differently. If the company policy was to provide 5 days, well, then there's going to be no entitlement at all to Idel pay because the company policy is greater than the statutory entitlement, and there will also be no entitlement to reimbursement from the Wsib. So if your company provides less than 3 days entitlement, the ESA will essentially provide a top-up of an additional day or days, and then you as a company will be able to apply for reimbursement from the Wsib in regards to that additional day or days. So I do recommend that you make sure as an employer that you're properly tracking your days and that you properly understand your current policy regarding such days. So to give you an example, it could be that your policy provides for personal days, okay? Let's say your policy provides for 5 personal days. And you may be of the view that those 5 personal days aren't the same as this new Idel pay entitlement. And so you may be of the view that you're going to provide 5 personal days and now 3 Idel pay days. And you would be entitled then to be reimbursed in regards to those 3 Idel pay days. So it's very important to figure out what your current policies are and to what extent do they overlap with the Idel pay entitlement, or extinguish the Idel pay entitlement. And then to the extent that they don't overlap or they don't extinguish, you will be obligated to provide Idel pay, and you will be entitled to be reimbursed from the Wsib in regards to Idel pay. And if any of you were thinking that now's the time to update that policy so that you will be eligible for Wsib reimbursement, the legislators foresaw that possibility and made it very clear that too bad, too sad, unless you did it before this bill came out, somehow maybe you had an inside line, as I've heard rumblings of some businesses potentially having, you cannot amend the policy in order to make yourself suddenly eligible for Wsib reimbursement. So you really have to look at what policy that you had in place, on April 28th, and then use that policy for determining what's owed to your employees and what you're eligible for in terms of reimbursement. All right. So that's the presentation. And as I mentioned beforehand, what I'm going to be doing now is I'm going to be answering questions that you have in regards to COVID-19 in the workplace and sick pay. And more than welcome to ask questions outside of sick pay, but just stick to employment law, please. Don't ask me about random other things. All right, so the first question, are these 3 paid sick days required in addition to existing days as outlined in our company policy and procedure manual? For example, we grant 5 paid sick personal days. Do I need to increase it to 8 in order to be compliant? So what you have to do is you have to determine whether or not the 5 days that you grant would apply or do overlap with the new entitlement to Idel pay. If an employee wouldn't be able to use them for Idel pay, so for example, if because they're, the way that they're defined or used, it's not really the same thing, then yes, you would have to do the 5 days plus the additional 3 days. But if it's clear that the 5 days would include the 3 days for the reasons provided in regards to those qualifying DIDLs, then you don't have to provide any additional days. You would then still remain at 5 days, but those 5 days would entirely be ineligible for Wsib reimbursement. Okay, next question, should Idel pay earnings be included when calculating public holiday pay? Great question. It's a leave benefit and it's not normally considered wages for the purposes of calculating holiday pay entitlements. If an employee stays home sick during this time, do we need to request more information to qualify them for Idel? If so, other than COVID test results, what can be requested? So if an employee says that they're not well and they're staying home, normally an update as to them receiving the COVID-19 test and the results is generally what you're looking for. So first of all, it's important that you ensure if someone's taking time off right now, that they're taking time off in regards to COVID-19. Obviously, individuals can be sick for a variety of reasons. In order for them to qualify for Idel pay, it can't just be, I'm not feeling well, so I'm staying home. It has to be, I'm not feeling well, and I have symptoms of COVID-19, so I'm staying home. And if that individual is doing that, what would normally happen, what most employers are recommended to do is to, first of all, direct the employee to take this self-assessment questionnaire as shared by the Ontario government. And then that questionnaire will in turn tell them that they need to go and get tested. And then you as an employer would ask for a copy of the document confirming that they're going to be tested and when they're going to be tested, and then confirming the results of them being tested. So next question, are the 3 days considered days as in 8 hours? Can it be taken in bits and pieces? So 2 hours one day 8 hours another, 6 another, or is it considered units similar to the personal emergency leave units? So for example, if someone needs 2 hours off, that uses an entire unit of the 3 leave remaining days. So the way that the legislation is written is to provide that they're entitled to 3 days of pay, up to a maximum of 200. There has been discussions that you could potentially use it in regards to half days, but so far the communication and the way that the legislation works is that they're entitled to 3 days. They don't have to use those 3 days all at once. So for example, if they go off on a qualifying diddle, they could use one of the 3 days at that point in time and hold back on the other 2 days. And the employee is allowed to write to you to request that even though they are on a qualifying diddle, that it be treated as an unpaid diddle because they're still entitled to that COVID-19 leave. And then of course, if an employee does request that they not receive their Idel pay, that employee may in turn then apply to receive other benefits through the government, such as the Canada Recovery Sickness Benefit or the Canada Recovery Caregiver Benefit. So an employee is allowed to ask that they not receive their Idel pay and at that time and instead wait to receive it later. So next question, I'm confused about the May 13th submission of Idel pay. Who submits what and how? So as I was mentioning before, these legislative amendments are retroactive to April 19th. So essentially, if someone was on a COVID-19 related leave between April 19th and April 29th, they are entitled to Idel pay. But in order to receive that Idel pay, the legislative amendments require that the employee let you, the employer, know that they want their Idel pay in regards to that leave. Otherwise, if they don't let you know by May 13th, tomorrow, then they still have that entitlement to Idel pay. So it's not like the entitlement goes away, but they're just not going to get that Idel pay in regards to the COVID-19 leave that they were on between April 19th and April 29th. Okay, next question. We are exempt from Wsib. Can we still apply for sick pay through them? Yes, you can. Even though Wsib is handling it, it is not limited to employers who are registered with the Wsib. My understanding is that the government has made the Wsib responsible for handling sick pay obligations because the Wsib currently, to my knowledge, is approving all claims that they receive in regards to individuals, workers who transmitted COVID-19 in the workplace or are suspected to have transmitted COVID-19 in the workplace. And so because they're already currently paying out benefits, it's better for them if they're able to continue to track pay entitlements so that their loss of earning benefits that the employees are receiving are addressed accordingly. So that's my understanding of why the Wsib is going to be managing it, as opposed to, say, doing it through a tax credit or another program. But at the end of the day, no. For employers who are not registered with the Wsib, you are not precluded from applying for the Idel pay reimbursement. You can still apply for it. Okay, next question. Can we submit for reimbursement on a monthly basis or after September 25th? So you have to submit it by the earlier of 120 days or the January deadline. So essentially what that means is that you will be submitting the application on an ongoing basis. If you want, you could do it at the end of each month, right? If that's what makes things easier for you on a paperwork front, at the end of May, you can go through, determine who all has received Idel pay, and then provide it. Or you could do it on another basis, say a quarterly basis. You just have to make sure, though, that whenever someone receives Idel pay, a 120-day clock has started to tick in terms of how long you have to submit a reimbursement request to the Wsib. All right, next question. Another issue arising from COVID-19, a provincial judge recently ruled in favor of laid off employees and allowed in his judgment that that layoff was actually a constructive dismissal. Has this decision put employers at risk who had to lay off staff early in COVID-19? Interestingly enough, I'm going to be handling the appeal of that decision. But what that decision means is that for those of you who have laid off employees, the legislation provided that those temporarily laid off employees, so individuals who the employment relationship was paused because of COVID-19, if they didn't sue by May 29th, that they weren't constructively, they can no longer claim that they were constructively dismissed or effectively fired for statutory termination entitlement purposes. Now, there was a question whether or not that legislation meant that the employee can't sue at all. So if they don't sue by May 29th, they can't claim at all that the temporary layoff means they're effectively fired. Well, the Ministry of Labor, through that policy and interpretation manual that I referenced before, they took the position that no, it doesn't mean that. It only means that they cannot sue in regards to their statutory entitlements. When an employee is dismissed, they have two types of potential entitlements. One is statutory entitlements, and that's their minimum entitlements. And the second is common law entitlements, which are normally much more substantial and apply to any employee who doesn't have an employment agreement restricting them. And the Employment Standards Act, according to the Ministry of Labor, only precluded that first entitlement, that statutory minimum entitlement, but didn't preclude the common law. Now, the court decision in issue here said the statute doesn't preclude either of the things, which obviously I think is wrong. But what this decision means, though, is that for those of you who do have employees that are on temporary layoff right now, it is possible that some of your employees may start considering commencing an action claiming that they have been effectively fired. Now, in that case, that employee actually got a job right away after claiming that they had been constructively dismissed. So the judgment was for a whopping $6,000, showing once again, the only people who win in litigation are the lawyers. So the takeaway, though, for employers is that if you can recall your employees, recall your employees. If you can't recall your employees, try to be open in terms of when you think you can so that they're not tempted to call one of those lawyers they see on CP24. And if you know you'll never be able to recall an employee, or if you know you never want to recall the employee, it may be time to consider not just straight out firing them and negotiating, but instead just opening the communication in terms of saying to them, we appreciate you're currently on layoff. If you would like, we're open to discussing a mutual separation package and then presenting them with an offer. That way you're discussing it before even pulling the trigger. And I'll also say it's a benefit for employees because a lot of these lawyers operate on a contingency basis. So if you do make an offer, the lawyer will only be entitled to any new money they can get, as opposed to taking, you know, anywhere between 25 to 50% of the entire package as fees. So the next question, what if an employee has exhausted their employer provided sick days before April 19th? Are they entitled to one additional Idel paid day or three? Great question. So the provision provides that it applies effective April 19th. So that one could argue that you are now obligated to provide additional days. I would think, though, that the safe bet is to say that they had received and already benefited from paid sick days, but I could certainly see that going either way in terms of how the legislation is written. creating some ambiguity there. If the employee takes, say, 1 day to get their vaccine, would they still be entitled to 2 additional days if they require it for another qualifying reason? Yes. So let's say they go, they're following vax hunters and they find a place where they can go get a vaccine and they take a day off because they have to stand in line. And then the next 2 days, they're just not feeling well for whatever reason. And so they say that they're recovering, then that individual will be entitled to 3 days in regards to it. Again, though, this is where we get into those issues because you can't ask for a qualifying doctor's note. So what are you going to ask for to show that they're in fact recovering, right? Like we always make jokes about how kind of silly this is because like, I guess, I don't know, you ask them to take a photo of their thermometer. Like, I don't know what you do. But technically you could ask them for things in order to confirm that they really do need those additional times off, maybe check their Insta account, that they're not just posting that they're partying it up somewhere. But all right, next question. Do suspected COVID-19 positive people who are in quarantine qualify, or does the Idel apply to only positive COVID-19 cases? No, it applies even if you're suspected and you're quarantined. So you don't actually have to have tested positive for COVID-19 to be entitled to Idel pay. You could be entitled to Idel pay if you've been instructed to self-isolate. So for example, you're waiting to be tested and you have symptoms. You could be entitled to Idel pay if the company has told the employee, we need you to go home because we're concerned that you might have COVID-19. So I found the easiest way to figure out if whether or not someone should be quarantining is to have them again take that provincially provided self-assessment questionnaire. And that questionnaire will tell them whether or not they should be self-isolating. As employers, though, you also have to be mindful that there's another thing that your workers should be doing if they're coming into the workplace, and that is taking that daily questionnaire, that daily screening. And if they're answering yes to any of those daily screening questions, then again, this is someone who's going to be sent home and will be entitled to Idel pay until they're able to come back in. So next question, is Idel pay considered insurable and pensionable earnings? I think the question there is for in terms of EI and CPP deductions. It's a payment in lieu of wages. I don't believe the CPP Act or the EI Act have been specifically amended to address this. I would treat it the same as any other sickness benefit that a company provides. So historically, those types of payments are do have tax deductions that apply to them. If your company does not have a sick leave policy in writing, can you still apply for Wsib reimbursement? Yeah, so you do not have to have a sick leave policy in writing in order to apply for Wsib reimbursement. If though you do provide paid sick days and you apply for reimbursement, you're going to want to make sure that you can clearly explain to the Wsib why these paid sick days didn't extinguish or reduce the Idel pay entitlement. Because obviously there could be substantial issues if the Wsib catches wind that in the past you've always provided your employees with 5 days of sick pay, even though it's not in writing. And now all of a sudden you're applying for Wsib reimbursement in regards to Idel pay. So if you do not have it in writing, you're going to want to be able to provide or have some sort of way of confirming what the terms of that policy were so that you can clearly demonstrate to the Wsib that you are still eligible for Idel pay reimbursement. Okay, next question. If an employee had to leave work because of a sickness from a vaccine and their mother also works here and had to drive them home, for 45 minutes. Is the mother qualifying for Idel pay? Okay, so whenever we have an Idel pay question, the first thing you always want to ask is the person on that designated infectious disease emergency leave, so the DIDL leave? So in this instance here, this person, the mother, she is having to take time off of work because of her child, a person who's, because of her child having to be driven home. And so that person is in fact on a DIDL, so on a COVID-19 leave for that balance of the day. Is it a qualifying DIDL? Yes, because it's a person who's their child and it's in regards to getting a vaccine. Do they have to receive Idel pay? They can for sure receive Idel pay. But in this instance here, I think the most prudent course for you as an employer will be to ask that person, do you want to receive your Idel pay now? Because it could be that they'll say, no, I want to save the Idel pay entitlement for another day. Okay, next question. Would these payments be calculated in income used for the CEWS, so the wage subsidy program? I don't believe the wage subsidy program has been amended to address this, but I do know that the wage subsidy program generally has specific provisions dealing with the fact that you can't be double dipping. So you can't be claiming in regards to payments for which you're already receiving reimbursement. So I would be very careful not to include it as something that could receive wage subsidy if you're also going to be eligible for Wsib reimbursement in regards to those payments. So traditional sick pay that's, was already, like let's say your company promised 5 days of pay in the handbook. Well, I would say that those 5 days of pay would be included for income purposes for the wage subsidy. And they're going to be exempt from Wsib reimbursement. But if you're now suddenly paying out new days because of this program as Idel pay, and you're applying for and receiving Wsib reimbursement, I wouldn't try to receive wage subsidies in regards to that. If the workers work a different number of hours of shift, how does their pay for the day be calculated? So it's based on what they would have earned on that day. So if, let's say, they were scheduled to work on Thursday for 6 hours, they would get 6 hours pay, okay? But the things that change are if, let's say, they were scheduled to work 6 hours on Thursday, but because Thursday is somehow like a special day at your workplace and they would have received double pay that day because of Thursdays, then they don't get the double pay. They would just be paid their regular pay for that day. Next question. We have 5 paid personal emergency leave for salaried employees, which can only be accessed if needed after all vacation has been taken. Would the employees be eligible for 3 Idel pays in excess of these days? Yes, I think they would be because of the requirement that it's only accessible after all vacation days are taken. And that is not a condition requirement for the Idel pay. So my view would be that they would be entitled to the 3 Idel pay days, in addition to the 5 personal days that you provide for, and that you would be eligible for Wsib reimbursement in regards to those days. The confusion, of course, would be if any employee had already used all their vacation days by April 19th and was therefore already entitled to the 5 personal days, could you argue the other way? Hypothetically, I suppose you could, but I would still view it as you would get the 5 and the 3 because of the different qualifiers. And just so that you understand as a context, back in 2018, we had temporarily in place legislative amendments that provided for very similar sick pay underneath Bill 148. Now, those legislative amendments were subsequently reversed when the Conservatives came into power. But when those legislative amendments were in place, the Ministry of Labor's view was that if you had a policy, for example, which provides for days, but the threshold, the benchmark, the test for it was more difficult or cumbersome than what the statute provides, then your policy doesn't overlap. So next question. If your company does not have a sick leave policy, oh, I think I got that one already. Next question, does an employee have to ask for the Idel pay, or does the employer just have to pay it because they know they're off? So for leaves between April 19th and April 29th, the employee has to ask for the Idel pay. For anything after April 29th, the employer has to just pay out the Idel pay, but once they know that the employee is on a qualifying Idel or qualifying COVID-19 leave, but the employee can agree to have their Idel pay used later. So my recommendation is always that as an employer, when you're communicating with an employee, you one, confirm if they're on a designated infectious disease leave, and then two, you confirm if it's a qualifying designated infectious disease leave. And then you send an email to the employee saying, you know, further to our discussions, we're confirming that you are now being placed on a leave as a result of X. In accordance with the Employment Standards Act, you are entitled to Idel pay, which is a maximum of $200 per day for up to 3 days. Do you want to use all or some of these days now, or would you like to save some of those days for later? So as an employer, I recommend that you just ask. There's no like laws against asking. And it could be that the employee, because they were only off for part of a day, that day was going to be low hours of work, whichever reason, that employee might say, I'd like to save my Idel pay for later. And the employee is allowed to do that. The employee is allowed to ask that it be saved for later. And I think that that avoids any sort of unnecessary complications or potentially the Ministry of Labor being brought in over a fight over, you know, when and how Idel pay should be paid out. So my recommendation is to explain to the employee that they're entitled to it and to let them know, do you want to receive it now or would you like to receive it later? If that conversation happens to occur over the phone instead of by email, I recommend that you then confirm the conversation in writing afterwards though. And that way you'll have a written record of it confirming that they are receiving or not receiving the Idel pay. It's good both so that you can keep track of how many Idel pay days an individual has left, and so that you can keep track in terms of the Wsib applications for reimbursement. So next question, what documentation do we need to provide to support the Idel claim for absences? Like I didn't have them filling out a screening document. Okay, so for all employers that have employees coming into the workplace in Ontario, you are currently required to have your employees fill out a daily screening questionnaire, and you are required to keep a copy of that so that if the Ministry of Labor comes by, you can show that you are actively screening your workers. So that means you should be having that questionnaire filled in, and someone should be tracking it to make sure that no one's coming into the workplace who's answering yes to any of those questions. So that questionnaire in part is a great way to determine if someone is entitled to a leave, because if they're answering yes, they're entitled to it. Otherwise, if someone doesn't show up for work but says that they need to stay home because of self-isolating, then again, you'd be able to ask for documentation in order to confirm that they need to stay home. Is there any payment for days off for getting the vaccine? Yes. You are entitled to, employees are entitled to Idel pay in regards to in regards to getting vaccinated and recovering from being vaccinated. Will Idel pay have an effect on our Wsib premiums? No. We have a new Wsib premium regime that went into place as of January 2020. And essentially what it means is that claims will no longer have any substantial impact, or shouldn't. And certainly Idel pay reimbursements should not have any impact on your Wsib premiums. Next question. I have been asking employees to fill out a form and check, like mark one of the COVID-19 reasons dates and then their signature. I did not collect any reasonable documentation until now because I thought we were not allowed to. Should I change it to request reasonable documentation now? Yeah, you could ask for reasonable documentation. You don't have to. It's not like the WSIB is going to say like, oh, we're not giving you your reimbursement because you didn't ask them for a picture of their thermometer. But you are able to ask for reasonable documentation. I recommend that you be consistent on that. So, you know, if the guy that you hate goes off on leave, you can't ask for him, you know, way more from him than you would from someone else. Be consistent, but it's entirely fine to ask for reasonable documentation. Next question. We offer 2 paid sick days already. Would we only be reimbursed for the difference? In other words, 1 day. That's correct. You would only be reimbursed for the 1 difference. Okay, next question. If a staff has to start self-isolating and they want to use their vacation days during their self-isolation period, can they do that instead of accessing these sick days? Yes. So an employee can ask to hold off and use their Idel days later on. And again, I really do strongly recommend an open communication where you're confirming that they're on a COVID-19 leave, that they have the entitlement to Idel pay, and asking them if they want to receive their Idel pay now or at another point in time. And it could be because of the reasons for their leave or otherwise that they might be preferring to go after things like the Canadian benefits that are provided for employees instead of using their Idel pay at this time. Okay, next question. If an employee is on probation and does not have access to the employer's regular sick pay days, can they qualify for Idel? Yes. So again, looking back in terms of how the government dealt with it last time they tried to do sick day pay, essentially if your policy has a higher threshold or a different test to be met, then the employee is going to be entitled to that Idel pay. So if the statute says they get Idel pay and your personal policy, your company policy says they don't get any sick pay, then they're going to get the Idel pay. Okay. If we have a 15% payment of which some of these things for sick day pay, are these additional days still payable / owed? So depending on what you have as your policy, it could very well be that the Idel pay is still owing, especially if they would receive less than what they're entitled to underneath these provisions. Can you direct staff to use their employer paid sick days if available, for instances such as they need to self-isolate, even though that definition is not outlined in the employer sick policy? So if an employee is entitled to 5 personal days, and those 5 personal days include you were sick, you need to move, whichever, then my position would be that those 5 days would include the 3 Idel days. So they're not entitled to anything more than those 5 days because the threshold, the test to be met is even lower than the Idel pay. And I would tell them that they aren't entitled to Idel pay then. They are only entitled to those 5 days. What if a company provides 12 sick days per year, but the accrued prorated pay? The employee may have only accrued a portion of the paid sick days. Can they get reimbursement? So if as of the time of the claim, the employee is entitled to less than what they would be underneath these provisions, then I would say yes, they would still be entitled to the Idel pay, and yes, you'd still be entitled to WSIB reimbursement. But I will note that because of any time you have a company policy, you need to be ready to explain to the WSIB if they ask. I don't know if they will though. I mean, they'll probably ask for some employers, but there's going to be a lot of applications. So they're going to have to figure out some way of determining how and when to perform audits. Okay, ADP, which is a payroll processing or accounting processing software, has added COVID sick pay, which is shown on the individual's time card. But when it gets paid out, it shows as regular earnings. Should ADP change this to show separate pay for COVID-19 related reasons? Or is the form within their signature card plus the time card be as good enough proof? So I prefer on individual pay stubs to have categories broken down. So regular wages, sick pay, vacation pay. I prefer those categories. I'll just leave it at that. If ADP's watching, you understand my position. All right, next question. Face mask wearing in the retail environment. If customers insist that they do not want to wear a mask or a face covering, what are the customer's rights? What are the store owner rights? And if the customer says they are exempt, are they required to show proof? Okay, so my recommendation on this is that individuals have a right pursuant to the Human Rights Code to be protected from discrimination on certain grounds. And one of those grounds includes disability. So if someone is unable to wear a mask or face covering pursuant to because of a disability, they have a right to be accommodated and you cannot discriminate against them. So what does that mean for you as a retailer? My recommendation is that if your business can still serve them otherwise without giving them access to the store, then that is the path that you may want to take. So what that would mean is you would have a sign up on your door saying mask required. If you cannot wear a mask, then do X. Please shop online. Please give us a call and let us know what you want to pick up and we will bring it to the door for you, right? So you have other ways of servicing that individual, and that way you're protecting everyone's health and safety because no one's coming inside the store without a mask on, while at the same time accommodating that individual by still giving them an ability to shop from your store without actually coming into your store. Okay, I will take two more questions. If an employee was off for 6 days in regards to COVID-19 symptoms, testing, waiting results, can they apply for the CRSB, which is the Canada Recovery Sickness Benefit, for the first week, and then take 1 day Idel for the 6th day, or do they have to take, the 3 days have to be taken first? Okay, so the Canada Recovery Sickness Benefit provides $500 per week for a period of 2 weeks. So this person here was off for 6 days. So essentially what they could do is they could apply for, as this person has noted, for the Canada Recovery Sickness Benefit for that first week. And then for the 6th day, which happens to fall in the next week, they would have two choices. They could ask for their Idel, or they could not take their Idel. And so it's really important, again, I can't stress this enough, why you need to have that open discussion with your employees. Because you as an employer might have just thought, oh, the person's taking they're off for 6 days, so I will give them their 3 days of Idel pay. But maybe this employee doesn't want any Idel pay. Maybe they want to keep their 3 days for later. Maybe they only want 1 day of Idel pay in regards to the 6th day, as the person has noted here. So that's why that conversation is important. The person can pick between getting all 3, getting only 1, getting some of them, but you just want to have that conversation so that it is clear and in writing that the person has asked not to receive their Idel pay yet, or not to receive all of their Idel pay yet. Okay, next question. If an employee is working from home, do we still need for them to fill in the screening questionnaire at home? No. The daily screening questionnaire is only something that's required to be completed if an employee is working from the workplace. And I'll post in the question box the the screening questionnaire so that you all have a copy of it. And how you implement that screening questionnaire varies. I have some clients who have an email address and the employees email it into it. I have other clients that have a Google form that's linked through their website that employees fill in, and then that's sent off to an email. I have some clients that do a hard copy. I have some clients that have apps. So there's very varying ways that you can get that screening questionnaire completed and actively monitored, but you have to do it for all employees that are coming into the workplace. All right, well, that's it.
Thank you, Christine. Wow, overwhelming. I don't know what else to say. Christine is our go-to person. Wilson Vukelich has been supporting the Board of Trade and our members and the business community for quite a few years now, providing information such as this. She'll be speaking again for us over the next few weeks on several other HR issues. So please reach out to Christine at any time if you have questions. I'm sure she'll be happy to, if she can, help you. But please join us. She will be speaking on the 25th of May and on June 2nd for the Board of Trade. I hope you enjoy the session. We will be emailing to you shortly the PowerPoint presentation. We have recorded this event as well, and that will be available shortly. We will email you the link once it is available over the next few days. But I hope you've enjoyed the experience and learned a lot. And again, thank you, Christine and Wilson Vukelich, for this amazing session. Have a great day, everyone, and we hope to see you soon. Stay well.